This is 26 CV 002825. It is a divorce matter, but today I think we're talking more about some trusts and motions to quash subpoenas and compel discovery, and one question about representation. It would be helpful for me to figure out who all these lawyers are here for, and most fundamentally, how to pronounce the last name of the litigants. So I'm going to start with petitioner's side.
Yeah, good afternoon. Patricia Shoemaker, Your Honor. I represent Christine Safier, along with co-counsel Bonnie Stinson and Vivian Gilbert.
All right. So you say Safier.
Safier.
Okay.
Safier.
All right. Is your client here?
No, Your Honor.
Okay. Was she supposed to be here?
Your Honor, my understanding was his attorneys only since it's a discovery dispute.
Okay. All right.
How we originally were noticed.
Good. That's fine. If we're keeping it at discovery, then. And at the respondents table.
Good afternoon, Your Honor. Adam Leckland for Tony. I've always called it Safier, but Safier. But you know the simplified version is Tony Safier.
Okay, and he doesn't wince when you say that.
He has not.
Okay, Safier it is. All right.
And it would be unusual for me, but I don't anticipate doing much speaking, if at all, today.
All right.
Okay, good afternoon, Judge McBurney, Tish McDonald, and Emily Newton with King & Spalding. We're here on behalf of what I will term the non-spouse trustees. There are 3 trusts at issue. We represent Mark Dirth, who is a trustee of all 3 trusts we're going to talk about, Buck Hill, Orby, and Terra Santa. And they're also here on behalf of James Mola, who is the trustee of 2 of the trusts, Buck Hill and Orby.
Okay.
Mr. Dirth is not here. He had a conflict, but Mr. Mola is.
Okay.
Thank you.
There's one more trustee in the mix, and that would be Mr. Safier, and he's represented by Mr. McGovern.
It's trustee, and then individually, of course, is Mr. Gluck.
Got it. All right. Any other lawyers who need to hear their name spoken in court? No? Okay, that's plenty. As I understand it, we're going to work through Ms. Shoemaker's concern, and any one of the lawyers can speak, but I'm going to shorthand it as Ms. Shoemaker's concern about discovery production from the trusts or trustees, as well as a concern raised about Mr. McGovern's apparent dual role, where there were instances where he made representations that would indicate maybe he was co-counsel with Mr. Gleckland on behalf of Mr. Safier in terms of the divorce, but also is wearing a hat of the lawyer for at least the trust, if not also the trustee, or maybe the other way around. But the Terra Santa Holdings Trust, Mr. Safier is one of the trustees. And so Mr. Safier plays multiple roles. But if he has an attorney or the trust has an attorney, the question was raised, how could the attorney representing the trust, whose interests may be at cross purposes with Mr. Safier, also then represent Mr. Safier in the divorce proceedings? I may have crossed wires because there are lots of trusts, but it had to do with Mr. McGovern wearing one too many hats in the eyes of petitioner. Is that a fair summary?
Yes, Your Honor.
Okay,
And I'll go into more detail.
good. You'll get a chance to do that. Were there other issues you thought we were tackling today?
No, Your Honor. Those are the issues as I understand them.
Okay. Given that, I think is why Mr. Gleckland said we may be blessed and not hear from him much today. Because these sound like trust issues and what the trusts ought to be disgorging or not. And then one representation issue that collides with Mr. Gleckland a little bit if, in fact, Mr. McGovern is playing a role on what I'll call the divorce team as opposed to one of or more than one of the trust teams. Have you, Ms. Shoemaker, since you began filing motions to compel and discovery disputes, et cetera, received discovery from any of the trusts so that we've narrowed the issues, or are we 0 for 3 with the trusts?
Your Honor, we are.
Okay, all right. Would you like to start with the representation question or the discovery question?
I'd be happy to start with representation. Your Honor, do you want to deal with that, or do you just want me to roll into the discovery issues as well?
Let's keep them separate.
Okay. Your Honor, and I applaud the court because there are a lot of moving parts, and it seems the court has already gotten a decent handle on some of what's going on.
Well, someone sent these pretty pictures that I asked for. I don't know where Dearth Law is. It's a sort of tough name, but it has, that's helped me understand a little bit, all the triangles and circles.
Your Honor, this is regarding our motion to disqualify Mr. McGovern. Your Honor, Mr. McGovern has long time represented Mr. Safier in his business litigation and business interests. He actually also represented my client in a lawsuit against her brother in 2008. And then early on in this litigation, actually pre-filing, Mr. Safier was in communication with me and my office regarding the divorce between the parties. In fact, there were discussions about the possibility of doing an informal exchange of discovery, a possibility of trying to settle pre-filing, and that was Mr. McGovern involved in those discussions. And in fact, in February, when it was apparent that this was going to be much more complex than just being able to settle pre-filing, I told Mr. McGovern that we were going to go ahead and file, and I asked him if his client would acknowledge service of the petition. He said yes, send me the paperwork. Interestingly, the same day that we filed the divorce, Mr. Safier made some changes to at least one of the trusts. So, and then we even went to mediation early on in May of this year, and Mr. McGovern was present along with Mr. Glecklin at mediation.
If you filed the divorce on whatever day you said, how soon thereafter did Mr. Glecklin file an entry?
Your Honor, it would have been, I have to go back and look at the pleadings for sure, and my associate can hold the pleadings.
And I'm not saying, gosh, why wasn't it in 3 days rather than 4? I'm just curious more so when he filed his entry, was it, I'm here with my brother attorney, Mr. McGovern, or it was, my firm is the representative of Mr. Safay in this proceeding?
No, the way the communication went down was, it's probably about a week later, I got the acknowledgement of service from Mr. McGovern. About the same day, I got an entry of appearance from Mr. Glecklin, which was a little confusing to me. I then reached out to Mr. Glecklin and said, wait a second. I got this acknowledgement of service from Mr.
Okay,
McGovern.
this is March 4th. I'm sorry to interrupt, but I've got the docket up. So March 3rd, the acknowledgement of service is filed. You may have received it earlier, but that's when it's filed. The next day, there's an entry of appearance and of course, leave of absence filed. And you're confused.
Yes, Your Honor.
Okay.
Absolutely. And Mr. Glecklin told me that he was the one representing Mr. Safier in the divorce. However, even after we had received Mr. Glecklin's entry of appearance, Mr. McGovern contacted my office, talked to my associate, Ms. Stinson, about getting car keys from my client.
Okay, and some of this is articulated in your motion. The relief you're seeking is to have Mr. McGovern cabined as business and trust lawyer and not divorce, or how do you see this being fixed?
No, it's more problematic than that. And this is where it gets very messy, because Mr. McGovern has also filed pleadings now, not only on behalf of Terra Santa Holdings. So he now is saying, okay, I represent Mr. Safier as the trustee of Terra Santa Holdings. He has also now filed pleadings. In fact, he filed a motion to quash our subpoena to Bank of America, representing Signature Destinations Unlimited LLC, which is a business entity owned by Terra Santa Holdings. He's also, as part of that motion to quash, represented that he is also representing Community Healthcare, which is a business entity. It's not on that chart, Your Honor. It's a business entity that's owned by Terra Santa Holdings and Orby Investments.
Why would it not, you didn't put together the charts?
Those charts did not come from me.
Okay, so they're not accurate, the charts? There are companies that the trusts own that aren't listed there.
That is correct.
Good thing I study these charts.
I would anticipate that the response to that is that community healthcare has been administratively dissolved by the Georgia Secretary of State, which it has. However, community healthcare is still involved in a lawsuit that is currently pending in Gwinnett County State Court.
Okay,
Your Honor, so Mr. McGovern now represents Mr. Safier in the divorce.
yep,
Terra Santa Holdings Trust, Signature Destinations Unlimited, Community Healthcare. He also represents Orby Investments Trust, of which my client is a beneficiary. And I know there's some dispute about whether or not she's still considered a beneficiary now that divorce is filed. But he's representing Orby Investment Trust in the lawsuit in Gwinnett County. So he has his
who
hand,
is Orby suing someone or is being sued?
both, Your Honor. Orby Investments Trust is suing to enforce a promissory note against a Dr. Jason Morris. Dr. Jason Morris has counterclaimed against Orby Investment Trust, and there's another trust that's involved in that lawsuit called Miramar Investment Trust.
Is that also a TBD, whose it is?
Your Honor, at this time, we've been provided a trust agreement, and we have no indication that Mr. Safier is involved with that trust. But discovery, I'm sure, will tell us
Okay.
if we need to dig more.
This Dr. Morris, how would he have a connection to Orby if all Orby is the owner of OPEX Investments?
Your Orby Investment Trust and Terra Santa Holdings Trust own Community Healthcare.
Oh, right. This is the
And-
one that you say is not in here, but maybe it's not in here because it doesn't exist anymore.
Right, but there's still pending litigation, and there's
Like with this doctor.
and there's an outstanding promissory note, which is what they sued in Gwinnett County. The countersuit is that Community Healthcare partnered with Dr. Morris to set up health clinics and mega churches. Now, Mr. McGovern has represented in his pleadings that Community Healthcare has not done any business, which would not be correct. I mean, there's press releases that these clinics were set up, but so Community Healthcare is central to that lawsuit that is pending in
Okay.
Gwinnett County.
So you've established that Mr. McGovern is representing a number of business interests and trusts that are connected to Mr. Safier, and maybe he's representing him in the divorce as well. Why, in your mind, is that a problem?
Yeah, a few things, particularly with the Orby Investment Trust. My client is a beneficiary. The trust and the trustee have a fiduciary obligation to my client as a beneficiary. This puts him at odds with that, both as representing Mr. Safier in the divorce and representing the trust and representing the business interest. And I can, talk about, the Georgia, it is really citing to the Georgia Rules of Professional Conduct 1.7, which talks about conflicts, and specifically looking at a couple of the comments to the rule. Comment 2 to the rule specifically states that loyalty to a client is impaired when a lawyer cannot consider, recommend, or carry out an appropriate course of action for the client because of the lawyer's other competition, responsibilities, or interests. The conflict in effect forecloses alternatives that would otherwise be available to the client. The critical questions are the likelihood that a conflict will eventuate, and if it does, whether it will materially interfere with the lawyer's independence.
Don't read too fast. The court reporter has to
I'm so sorry.
take down. People read faster than they think, so.
My apologies. Let me slow down. The critical questions are the likelihood that a conflict will eventuate, and if it does, whether it will materially interfere with the lawyer's independent professional judgment in considering alternatives or foreclosed courses of action that reasonably should be pursued on behalf of the client. Your Honor, Mr. McGovern's long-term relationship with Mr. Safier, the fact that he's representing him in multiple instances, and now he's also representing Orby Trust. Your Honor, he's also representing Terra Santa Holdings Trust, Your Honor, and the on Terra Santa Holdings, it's interesting because the trust document does not establish that my client is a beneficiary, but there is one place, and I think it may be, I don't know if it was intentional or not, but it does contemplate if there's distributions to the grantor's spouse. So him.
But the grantor for Terra Santa is someone named James and not Tony. Is your client married to James?
No, Your Honor.
Also, no.
Your Honor.
So that wouldn't be your client then?
No.
Okay.
Your Honor, but definitely, she's definitely a beneficiary of Orby Investments, and he is representing Orby Investments in the lawsuit in Gwinnett County. He's also representing Community Healthcare in their objection to the Bank of America records, which my client has asked for.
Okay. So is the fix in your mind that Mr. McGovern needs to be cabined to stick with the businesses and stay out of the divorce, or you can't unring the bell that's been rung and he, Mr. McGovern, needs to be not involved with anything that has to do with Mr. Safay at this time until the divorce is resolved?
Your Honor, I think it's the latter. The bell, you can't unring that bell. And the problem is he has so many conflicting interests and he has more than one master. He has two masters. You can't serve more than one master.
But if he is not accepting car keys anymore or telling you, hey, I maybe we can work this out, pre-filing, et cetera, and you're dealing only with Mr. Glecklin and people in his firm, this isn't a situation where you're contending, I don't think, that Mr. McGovern learned something about your client and about your case that he, because he wasn't representing ever your client. He may have learned because you spoke to him about the case. But what I guess I'm trying to figure out what the issue would be if the bright line is you're not involved with the divorce side of things.
Your Honor, I think it'd almost have to be, he's not involved in the divorce. But again, I mean, he did attend mediation. And, I know in his pleadings, he said that he was just there for personal support. He was at mediation.
But I guess what I'm trying to understand is how anything he would have learned from being involved with mediation would impact his ability and really what standing you have to worry about whether he could be an effective advocate for Orby Trust and Mr. Safay and whatever the name, Community Healthcare. Those are all, maybe he can't, I don't know, I'm not saying he couldn't, but if he is kept out of, no more mediations, you can't go to a late case review, you aren't, even as a supporter of, just you need to stay away because of these other issues. Have we not stanched the bleeding and we can move forward, or?
I think the biggest issue is with Orby Investments Trust, which my client is a beneficiary of. And he is representing Orby Investments, both in the Gwinnett lawsuit, and he's representing entities within Orby Investments. And that's I think probably the biggest issue, and then him participating in the divorce.
Okay. So you think that your client has standing to raise a conflict concern that Mr. McGovern represents not just the trust, but also a component of the trust because she's a beneficiary of the trust?
Yes, Your Honor. And the trust and the trustee have a fiduciary obligation to her. I mean, even as a beneficiary, she would be entitled to an accounting, which she's certainly not going to get if that's a classic example where Mr. McGovern is, he has a duty to my client, but by the same token, he is also representing Mr. Safier. And Mr. Safier is going to be like, okay, don't provide that stuff to her, which is where we're at now anyway.
Okay. And in theory, Mr. Safier may say that to Mr. McGovern, but if a judge says you need to provide the accounting, I'm not seeing where It's frustrating that the initial answer is no, but if the ultimate answer is yes, and it's signed by a judge, doesn't your client then get the accounting?
Yes, Your Honor.
And if Mr. McGovern,
Yes, I'm sorry.
well, I'm not seeing the reason why Mr. McGovern wouldn't be providing the accounting in the scenario you just described is because his client told him not to, not because he's got a conflict, but because the grantor of the trust is, I don't know why he wouldn't be talking to James and Mark. And I'm sorry, I'm not using their last names, but I just don't have that in front of me. I don't know.
Your Honor, which is exactly the point. I mean, there's what it appears, the appearance is that it's Mr. Safier directing it. And you're absolutely right. On Orby Investments Trust, Mr. Safier shouldn't be directing anything.
Okay. But regardless of who's directing it, if the correct answer is your client is entitled to bank records, financial statements, and accounting, it doesn't really matter what Mr. Safier says in the end. I mean, it's going to need to be turned over. And if it's not, well, we have all sorts of ways to make sure that it gets turned over. So I don't want Mr. McGovern's continued presence in the case to disadvantage your client, but I'm not seeing how, if the line we draw is stay away from the divorce, don't appear, not a guest appearance, not a comfort companion appearance. You can't be involved with any aspect of that other than because Orby Investment Trust is pulled into it and community health care is pulled into it because they are maybe assets at issue. He might be there as the representative for one or more of those things. If that is the picture we paint a month down the road, tell me how that doesn't adequately protect your client's rights. Because again, I know I interrupt, I'm bad at that. If your answer is because Mr. Safier is going to say, don't produce the accounting, I don't view that as a conflict issue. I view that as someone's cruising for a bruising if they don't provide the accounting, and they ultimately will. So.
Yes, Your Honor. Your Honor, and I, would have to concede that to the court. Again, I don't
want you to concede. I don't want to misapprehend the concerns you have. I understand your concerns. It's unfortunate that you had to have those concerns in this case. But if there is a way to address them short of denying someone his right to counsel of his choice, that's always the best path.
Yes, Your Honor.
And so that's what I'm trying to construct, which is why I asked if the things play out in that scenario I described, as fanciful as it might be, where is the ongoing harm to your client? Because I don't see it in that setting.
Yes, Your Honor. Your Honor, and again, I would concede that to the court. And again, the concern is going to be whether or not the trust and the business entities will be forthcoming.
Okay. So it may be that I'm certainly going to hear from Mr. McGovern or whoever is going to be speaking on his behalf. But it may be that we do a few things in response to your motion, like stay away from the divorce case, and then table it to see what flows over the next few weeks after we get some closure on the discovery concerns. And I don't want to prejudge it, but if the way the discovery conversation turns out is that there are very clear directives that things need to be turned over, and then they're not, and you see McGovern fingerprints on that non-disclosure, then clearly my forecast of what was going to happen was wrong, and we may need to do something different.
Yes, Your Honor.
Okay. All right. Thank you. Mr. McGovern, good afternoon.
Good afternoon. Your Honor, as I mentioned in my response, Ms. Safier has no standing to assert a conflict that may belong to Mr. Safier. And I certainly don't represent Mr. Safier in this divorce case. It's Mr. Adam Glecklin.
So the term certainly, though, maybe that's too strong a term, because Unless you're going to say Ms. Shoemaker was mistaken, she's described things that you've done that to an outside observer, I put myself in that category, I'd say, oh, look, he has more than one lawyer helping him. There's an entry of appearance, and then there is also, but who's on the legal team?
I understand, Your Honor, but, well, let me say that my participation after the complaint was filed and the entry of appearance was filed has been very, very limited. I did attend the mediation, as did Mr. Glecklin. Mr. Glecklin ran the mediation. I did, or I have filed documents on behalf of the Terrasanta Holding Trust on behalf of Mr. Safier in his sole role as co-trustee.
Okay, that part seems like in your lane, because there you are, I'm gonna call it business lawyer as opposed to divorce lawyer.
That's correct, Your Honor. Just if you give me a moment, just look at my fact pattern to make sure I'm not omitting any facts I told you.
It does sound like you've become less directly engaged in the divorce proceedings post-complaint. Earlier, you may have been having conversations directly with Ms. Shoemaker, but after Mr. Glecklin filed his entry, maybe you were involved in getting some car keys, and there's going to be natural overlap because of the trusts. But you are going to need to be very alert about keeping them as separate as possible.
Yes, Your Honor.
And something like attending the mediation, again, on the outside, I'd say, oh, there's Mr. Safe's legal team, Glecklin and McGovern, going into the mediation. And maybe because there are the trusts, you had an important role to play there so that no one said the wrong thing about the nature or structure or holdings of the trusts. I don't know.
Well, to be fair, my attendance at the mediation preceded my filing documents on behalf of the Terrasanta Holdings Trust.
Okay.
To clarify my involvement pre-filing, I never had any conversations with Ms. Shoemaker. It was just an email request or two with a standard request for documents to see if the case could be settled before filing a divorce. I produced the documents on Monday, the 23rd of February, 2026. And on Wednesday, the 25th, 2026, just 2 days later or 3 days later, Ms. Shoemaker emailed me and said, we're filing. Will you acknowledge service of process? Or will your client acknowledge service of process? And I said, yes. And then on March 2nd, I delivered a signed acknowledgement that was signed by Mr. Safier. And then on March 4th, Mr. Glecklin filed his entry of appearance, and I didn't know that he had filed it. And then on March 11th, Mr. Safier asked me to call Ms. Shoemaker's office to try to get some car keys that Mrs. Safier had. And
I think I appreciate that's a lone instance, but that fluidity where all of a sudden you're reaching out and not talking to a lawyer representing someone suing the trust or something like that, but the divorce attorney saying, hey, could I get this because husband wants this from wife? That starts to blur lines that you may not have intended to, but based on what Ms. Shoemaker is experiencing, I can see why she would say, well, wait, how many lawyers are there on the divorce side? Not that Mr. Safier can't have 20, but it starts to group you in with the divorce team.
I understand. I just want to read the standard, which I think you have your fingers on, Your Honor, is to have standing, a lawyer must substantiate a violation of rules which is sufficiently severe to call into question the fair and efficient administration of justice. And we review disqualification as an extraordinary remedy that should be granted sparingly. And the trial court balances the need to ensure ethical conduct against a client's right to freely chosen counsel, as you all already mentioned, Your Honor. I don't believe that there's been sufficient showing that what I've done so far is a threat to the fair and efficient administration of justice. To clarify a couple of things, Ms. Shoemaker mentioned community healthcare. Community healthcare is a defunct business that provided healthcare service at churches, and a podiatrist was involved in it. And he also,
Is that Dr. Morris?
yes. He borrowed money, and I was retained to enforce a promissory note. And that case is filed up in the Gwinnett State Court, coincidentally scheduled for a bench trial in 2 weeks. And Mr. Morris, or Dr. Morris, he counterclaimed with a variety of allegations with his involvement with signature tours. So
Why would he be involved? Maybe Signature Tours is not a travel business, it's the doctors?
Excuse me, I made a mistake. Community health care.
Okay,
So my other representations are as co-trustee of the Terra Santa Holdings Trust for Mr. Safier, and his co-trustee is Mr. Durr.
oh, so the Dearth, Mark is Dearth, Mark
Yes.
Dearth.
Yes.
Got it, now I've got my Dearth, okay. And what's James's last name?
Mola, M-O-L-A.
That's who's here.
He is,
Okay, how do you spell that?
M-O-L-A.
Hola, okay, thank you.
You're welcome. I also, Your Honor, I mailed a letter to Bank of America on behalf of Signature Tours. Bank of America gave Signature Tours notice that its records had been subpoenaed. And I sent a letter to Bank of America asking it not to produce the documents.
And the documents would have been, is this Terra Santa? So this would have been related to some financial aspect of Signature Tours, a third of which is owned by Terra Santa.
Correct, 100% correct. And so Terra Santa is a minority shareholder in Signature Tours.
Okay,
It just owns 1/3 interest. So when you get into analyzing the trusts, the motions to compel and the objections, et cetera, I filed a response on behalf of Terra Santa Holdings Trust, but Mr. Dearth filed a notice of joinder afterwards. And so to keep things more efficient, Emily Newton and Tish McDonald will just handle all 3 trusts.
when you say joinder, meaning Attorney Dearth said, I'm also filing things, what's being joined?
He adopted and acknowledged all the arguments that had been asserted on behalf of Mr. Safi as co-trustee.
That you had asserted?
That's correct.
Okay.
And to make the
Oh,
arguments.
as the co-trustee, he says, I adopt those arguments on my behalf as well.
That's correct.
Okay, and he filed that pro se, or
No,
that
he-
was,
it was filed by King and Spalding.
got it, okay. All right, so Ms. McDonald and Ms. Newton handled that.
That's correct.
Okay, got it. Okay. Anything else?
No, Your Honor.
All right, thank you.
You're welcome.
All right, your rest is over, Ms. Shoemaker. We'll come back up. I will admit to not having plumbed the depths of what was requested in discovery from each of the three trusts. If you think we can navigate this by staying at a high level, that's easier for me to follow. But if we need to get into, no, we needed bank account from this month, from this sub component of the trust, I'll follow you wherever you need to go. But it sounds like to date, you've received nothing at all from any of the trusts. So maybe we can keep it at the high level of knocking down the wall of, actually, you do need to provide these things, whatever they are, versus, oh, I understand why, and I'm making this up. Buck Hill, I haven't heard people say much about that one. You're not getting anything from Buck Hill. That's too far removed versus these others where you should get some things.
Yes, Your Honor. Your Honor, I would agree that we're at a high level. Your Honor, what I've been provided are the trust agreements for all three trusts.
And how did you get those?
Your Honor, actually, Mr. Safier produced those in discovery,
Okay.
his personal individual discovery. And then the trust also additionally provided the change of trustees because all the trustees were changed in February and April.
Okay, so you got all three. So that's a start. You have the trust agreements.
We have trust agreements for the three.
And as I understand it, your client is, at least originally, was a beneficiary in Orby. So that seems pretty topical. Was a beneficiary in Buck Hill.
Yes.
Also seems pretty topical. And then for Terra Santa, the beneficiaries are Mr. Safay and his descendants,
Yes, Your Honor.
which would not be your client, but would be their two kids. And I think there's a third kid in the mix, but
Correct.
importantly, it's descendants. So that is a little bit to the side. Doesn't mean it's irrelevant, but there's at least a connection that your client's kids are beneficiaries of Terra Santa.
Yes, Your Honor.
Okay.
Your Honor, Your Honor, I need to a little bit set the stage for the
Okay.
court. Your Honor, because initially, as with any divorce, we started out with individual requests for discovery from Mr. Safier. And the information that we have from Mr. Safier in his personal discovery is that he has no ownership interest in any business entity. He also has no income producing assets. In fact, initially he told us that the marital estate is worth negative $422,000.
Can make it hard to pay Mr. Glecklin.
Your Honor, he then updated that last week and now says that the marital estate is worth $476,000. Your Honor, Mr. Safier, in his financial affidavit, claimed that he makes $27,500 per month. However, he also claimed that his only source of income was as an employee, as the CFO and secretary of Signature Destinations. And he provided pay stubs, 3 pay stubs, for $5,000 per month. But there's no direct deposit into his his checking account. Your Honor, Mr. Safier says that he has 2 bank accounts, a joint checking and a joint savings account. Your Honor, however,
So if they're joint, then your client would know all about those accounts. I'm assuming it's joint with your client as
Yes, Your Honor.
opposed to
Yes, joint with
Mr.
my-
Durf.
Yes, Your Honor. Your Honor, and Mr. Safier provided those statements for the joint checking and the joint savings, and the joint checking account is very interesting. Your Honor, we also did a third-party notice to produce to American Express for his American Express records, which was also very illuminating.
And you got those.
And I received those, yes, Your Honor. Your Honor, since January 2020, and Your Honor, this is setting the stage for the trust. Since January of 2020, Mr. Safier has received deposits and transfers into the joint checking account in the amount of $5 million. Your Honor, and my client does not work. He also pays.
So it's lucrative being the CFO and secretary of Signature Tours.
Your Honor, but again, he makes $5,000 a month based on his 3 pay stubs.
Yeah.
And Your Honor, those are not direct deposited into his joint checking account.
Right. No, I heard you say that. So the 5 million in transfers, or I'm gonna call it inflow into the accounts, does it say where it's coming from?
Your Honor, it is coming from, well, I've got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 10 Bank of America accounts. 10 different Bank of America accounts. I know what one of them is. One of them is actually, I'm sorry, there's 9 bank accounts with different account numbers. There is,
But they're all Bank America.
yes.
Okay.
Because
And you
they're
subpoena
transfers.
Bank America, and that's one of the things that has been
Yes.
thwarted.
Yes, Your Honor.
Okay.
Your Honor, I do know that there are 2 wire transfers from OPEX Investments, which is owned by Orby Investments Trust, in the amount of $1.3 million.
Do we know what OPEX Investments does?
Nope, Your Honor, I have no discovery, absolutely no discovery, don't know what this is. All I've been told is that Mr. Safier does not have an ownership interest in this business entity, yet this business entity, for some reason, wired him $1.3 million.
Okay.
And he's not a beneficiary of the Orby Investment Trust either.
No. Okay.
So, Your Honor, I also have $1.5 million in deposits from a Morgan Stanley account. Your Honor, Mr. Safier has disclosed that he has a Morgan Stanley IRA with $72,000 in it. He's also disclosed that
Is that the same account, or it's simply at one point, Mr. Safaya said, hey, I do have an IRA, it's with Morgan Stanley. And then you know that there's a Morgan Stanley account that disgorged over $1 million into their joint account.
Your Honor, all I can see is that there's a Morgan Stanley account that deposited $1.5 million
Okay.
into their joint account.
Okay.
Your Honor, I do know that there is a Morgan Stanley account, maybe 2, maybe more, with the Buck Hill Trust.
Have you tried subpoenaing the Morgan Stanley accounts?
Your Honor, not yet.
Okay.
And certainly not after Bank of America, after that was blocked.
Okay.
That's gonna, now, Your Honor, that is coming, that we're going to send a subpoena to Morgan
But
Stanley.
we should talk first.
Yes, Your Honor.
Okay.
Your Honor, so I do know that there is a Morgan Stanley account, possibly a second one with the Buck Hill Trust. And Your Honor, I apologize, I'm kind of jumping around.
If you jump around with numbers as large as $1 million, you can jump around like that. If you're jumping around and he got $11,000 from a Coinbase, we don't need to talk about that.
Your Honor, there is a $2.4 million Morgan Stanley account in the Buck Hill Trust. That we've been given an account statement. We've been given, I think, like 3 account statements for that account. That account is titled under Buck Hill LLC, care of Mr. Safier.
So the Buck Hill Trust is 2 pieces of property and then the LLC. And the LLC is linked to over $2 million account.
Yes, Your Honor. And I have no information on the Buck Hill LLC. Georgia Secretary of State doesn't even register it as an entity.
Okay.
Your Honor, however, there at one point was a Morgan Stanley account in the name of Buck Hill Trust that also had $2.4 million in as recently as 2024. And in fact, the Buck Hill Trust, which again, Mr. Safier is not a beneficiary of, the Buck Hill Trust paid off Mr. Safier's promissory note to OPEX Investments to the tune of $2.1 million
When did this happen?
in 2024.
Okay.
Your Honor, this was associated with the purchase of the party's current marital residence, which is in Buck Hill Trust.
Is that Irma or Hillside?
Irma.
Okay.
Hillside is the lake house.
Okay.
Your Honor, so this is kind of laying the foundation of why the trusts become very important.
So assume foundation laid. Tell me what you think you're entitled to, and well, I guess you told me why. I mean, there's a lot of money sloshing around in here, and it doesn't jibe with the financial disclosure of, I basically have nothing.
Your
What
Honor,
are you told when you ask for it? Just no?
yes.
Not no because?
I was told no, because these are separate entities. And I'll go through each of these, kind of and I have kind of the cases Gibson versus Gibson and McGinn versus McGinn, which are kind of the preeminent cases here in the state of Georgia regarding trust. Your Honor, and McGinn.
Trusts in divorces?
Yes, Your Honor. Your Honor, and I have copies of the case law. Do you need them?
No, as long as you give me the citation, I'm happy.
McGinn versus McGinn is 273 Georgia 292.
292,
The
okay,
Georgia Supreme Court case in 2001.
yeah,
Your Honor, in that case, and that was a divorce, husband was the beneficiary and co-trustee of a trust. The sole asset in that trust was stock in a family-owned company. Of course, the husband's family. In that case, wife sought discovery on the formation of the trust, the value and financial records of the company within the trust, and compensation and benefits received by the husband from the company. In that case, the company and the husband objected to discovery, and the trial court there granted the company's motion for protective order and the husband's motion eliminate to exclude the evidence. And the trial court excluded all evidence related to the value of the stock and the assets and liability and income of the company. And that was the only asset in the trust. And the Supreme Court there reversed the trial court. And there said, look, even though the Supreme Court did find that the trust was husband's separate estate, the separate estate is still relevant and discoverable in a divorce for purposes of alimony
Sure.
and equitable division of property. And said that the trial court erred when it excluded the company financials because it was relevant to the value and earnings potential of the entire corpus of the trust. When I requested these records from the trust, they cited to Gibson versus Gibson, also a Georgia Supreme Court case. And the cite on that is 301 Georgia 622. That's a 2017 case. Again, it's a divorce, and at issue there were two trusts that were created by the husband during the marriage, and his mother was the trustee of both trusts. He, during the marriage, put $3.2 million in assets into the trust. Wife there claimed a fraudulent transfer, and the trial court determined that it wasn't. And the Supreme Court held that the property in the trust was subject to equitable division only if the wife could show that the transfers into the trust were fraudulent. So, there's really two reasons we need discovery on the trust here. The first is that even if the court determines that these trusts and all the properties in these trusts are separate, it's still discoverable for the purposes of alimony and equitable division.
talk to me about the equitable division part. I want to understand what you mean by that. If it is like the McGinn case, I think you said that, well, maybe it was Gibson. In one of the cases, they said, sure, that property ultimately was the husband's. And so it's not part of the marital estate. Why does I understand why it would impact alimony, because the ability to pay, you've got $3 million, not in a place where it would be divisible during the divorce because you had it before, it was inheritance, whatever it is. So it's not part of the marital estate. What would be divided then?
Yeah, I'm not saying it would be subject to division. I'm saying it's a factor in equitable division. For instance, if you have two parties that are going through divorce and you know that one of the parties has a large separate estate, you may say,
as I'm balancing the equities, what do we do with the 3 cars? It might be all 3 cars go with your client because there's $3 million over here. You'll be able to get a car out of that.
Right.
Whereas your client hasn't been working in the sense of outside the home, but has been doing lots of important things for the household, but not accumulating assets. And so you keep the cars And I don't need to worry so much that the person on the other side wouldn't be able to get a nice new car using some of the $3 million that's not part of the marital estate.
That's right, Your Honor.
Okay,
But
that makes
that's right.
sense.
A party separate estate is a factor for the court to consider in equitable division.
Okay.
Your Honor, so, and the second reason, Your Honor, why discovery is important, and that's.
Wouldn't that sort of be the end of what you need to show? I mean, all of this, if it's connected to Mr. Safay, would be something that I ought to be considering as part of equitable division.
Yes,
Mr.
Your Honor.
Gleckman shook his
I
head,
would-
but
Your Honor,
I don't know why we wouldn't just, okay, then let's hear, there ought to be some other good reason that it shouldn't be disclosed,
Your Honor.
privileged or something like that.
Their argument, particularly on the Buck Hill Trust and the Orby Investments Trust, is that he's not beneficiary of those trusts. Therefore, it shouldn't be considered. McGinn versus McGinn doesn't apply. Your Honor, now, and I can go, and there's more that I will share with the court, because I think it's important for the court to be aware of what I do know based on what little information I have gotten so far. But Your Honor, where we're going is with Gibson versus Gibson, because my client's also entitled to discovery under Gibson versus Gibson to determine whether or not these were legitimate transfers or fraudulent transfers, because that then determines whether or not these assets get pulled into the marital estate. Your Honor, and that's really where we're headed. And Your Honor, just.
Well, and if your client was a beneficiary of the Buck Hill Trust, it seems like anything that happened within it, she'd be entitled to see to make sure, I filed for divorce. And then the next thing we know, $1 million comes out of that trust and it just shrank. And so the benefit she'd get from it is a whole lot less.
Your Honor, I would agree with you.
Okay.
Your Honor, but I also, so there's multiple, I would agree with the court that there's multiple reasons why, we should be entitled to the discovery, least of which is that even if a separate property is still considered for alimony and equitable division, Your Honor, there are concerns that some of these transfers were not legitimate, that there's potential fraud with these trusts. Your Honor, I've touched on some of these, some of the high points. My client from starting with the Buck Hill Trust. My client, when that trust was created in 2012, my client was the trustee. Up until February 25th, the date that we filed the divorce. And Mr. Safier, he was the grantor of the trust, but under the trust document, he, as grantor, retained the right to remove the trustee at any time, which he did on the date that we filed the divorce. What's interesting is my client, even though she's trustee, she did not know about this $2.4 million account that is either belongs to Buck Hill LLC or belongs to Buck Hill Trust, or perhaps there's two $2.4 million accounts because they have different account numbers. The Buck Hill Trust, so Mr. Safier in 2024, he signs a personal promissory note in his name to OPEX Investments to the tune of $2 million. OPEX Investments wire transfers money to Buck Hill Trust. Buck Hill Trust purchases Irma, the marital residence, Irma Court. But then Buck Hill Trust, and then they sell their old marital residence, that goes into Buck Hill Trust account, Morgan Stanley account, and then Buck Hill Trust pays off Mr. Safier's personal promissory note to OPEX Investments. So there we have Mr. Safier receiving funds out of the trust where he's not the beneficiary. So then it starts to question, whether or not this was
Although
actually.
it bought a house that benefited your client.
Yes, Your Honor, but it also paid off a promissory note. And so there's issues of whether these assets were legitimately transferred into the trust. And Your Honor, if my client was the trustee and she didn't know about this account, how could she have received that into the trust?
Okay.
Your Honor, regarding Terra Santa Holdings, again, they contend, look, McGinn doesn't apply because, Mr. Safier, even though he's the beneficiary, he doesn't have the authority to appoint trust assets to himself, his estate, his creditors, or other recipients because there's a co-trustee. He's co-trustee with Mark Dirth. Prior to him changing the trustee or the trustee being changed on April 24th of this year, it was Mr. Safier and his oldest daughter, Danielle, who's not a daughter of the parties. However, in the trust document, it states that the trustee shall pay over to Anton Safier, who is referred to as the withdrawal beneficiary, so much of the principal of the trust as the withdrawal beneficiary shall demand in writing. So Mr. Safier could ask for all of the trust, and so long as he did it in writing, the trustee has to give it to him. Now, what's interesting is what they have disclosed about Terra Santa Holdings is that Terra Santa Holdings has a 1/3 interest in Signature Tours, which is also Signature Destinations Unlimited, which, Your Honor, I know from Mr. Safier's bank accounts and from the American Express records that Signature Destinations has paid at least $138,000 to his personal American Express card, and has also made deposits into his checking account of about $94,000. Again, these aren't direct deposits; these are transfers. Your Honor, also, what they did not disclose, it's not on your chart, is the community healthcare, which we've talked about, Community Healthcare of Atlanta. Your Honor, and even though I know Mr. McGovern says, look, it's a defunct business, there's still an outstanding promissory note of $125,000.
Meaning someone in theory owes community healthcare that amount?
Well, Your
Is this the Dr. Morris?
Your Honor, yeah, that's why they're suing Dr. Morris, but it's Orby Investment Trust, which owns community healthcare. But then Orby Investments and Terra Santa's Holdings both own community healthcare.
Okay.
Your Honor, there's also a Botanamedics LLC, which they did not disclose, which is an active business entity under the Georgia Secretary of State that is owned, I believe it's owned by both Orby Investments and Terra Santa Holdings.
And how do you find these things out if you have no discovery on what's in the trusts?
Georgia Secretary of State.
So if I look up Botanics Medical, whatever, it would say owners and it would list the two trusts.
It gave me the organizers. The organizers for Botanamedics were Orby Investments and Terra Santa Holdings.
Okay.
Yeah, so, and some of this was also, we found out about the lawsuit in Gwinnett County, which led us to some additional, that led us to community healthcare, which also led us to the promissory note. That led us to the promissory note. That actually led us to Orby Investments. I mean, Orby Investments was not even initially disclosed.
Your client didn't know
She
that.
did not know that Orby Investments or Terra Santa Holdings existed.
Okay.
Your Honor, and regarding Orby Investments, and we've kind of talked about the promissory note, OPEX Investments wired $2.8 million to the Buck Hill Trust for Mr. Safier's promissory note. And Your Honor, and I touched on this, that OPEX Investments, again, which is owned by Orby Investments Trust, wired to Mr. Safier $1.3 million. And he's not a benefit, he is averred to us that he's not an owner of OPEX Investments. And he's not a beneficiary of Orby Investments, but somehow he got $1.3 million from OPEX Investments. Also, and I believe that this is tied to the trust. I don't know, but since January of 2021, Mr. Safier, between his joint checking account and his American Express card, has received $1.6 million from a Bank of America account ending in 0561. When I asked specifically about this account, I was told by Mr. Safier's divorce counsel that this was an account titled in the name of Global Investments Limited LLC, and I have no idea what that is. I don't know if it's in one of the trusts. I don't know, I don't know anything about this, you know, so what we're looking for is, you know, we need to know what are the assets in the trust for any business entities in all three trusts. We need to know, we need all the company financials. We need profit and loss statements, we need tax returns, we need gift tax returns for when these assets were allegedly transferred into the trust to determine whether or not these were legitimate transfers under Gibson versus Gibson. We need enough financials for these company interests to be able to value these companies under McGinn versus McGinn. You know, there's it's a lot of information. You know, and so far we've gotten the trust agreements.
Okay.
You know,
And you've asked, I'm not going to hear from any of the lawyers, well, no one's asked for these things.
no, Your Honor, we have asked. We noticed the trustees for deposition, and with it, we sent a subpoena for documents.
And that would be one way Mr. McGovern resurfaced because he objected to the deposition of Mr. Safay as trustee of Terra Santa.
Yes, Your Honor.
Okay.
Your Honor, and I will say, when we noticed them for deposition, at that time, we did not know that the trustees had all been changed in April of this year to add Mark Dirth as co-trustee.
He was not originally a trustee of any of the three.
Your Honor, I let me see if I can. The original trustees on Orby Investments was James Mola and Danielle Safier. On April 24th, Mr. Safier changed that to James Mola and Mark Dirth. The Terra Santa Holdings, the original trustees were Mr. Safier and Danielle, his oldest daughter.
Mhm.
On April 24th, that was changed to Mr. Safier and Mark Dirth. The Buck Hill Trust, the original trustee was my client. Here, and then on February 25th, Mr. Safier changed that to James Mola and Mark Dirth.
Okay.
So when I think that when I initially noticed these, I didn't find out about this change until I think end of May. So when I originally noticed them for deposition, I noticed James Mola for Buck Hill Trust and Orby Investments and Mr. Safier for Terra Santa Holdings.
Got it.
Yeah, and with that was a request for documents. Bank of America statements.
These would be whose Bank of America statements?
What we had asked for was Bank of America statements, any accounts in Mr. Safier's name, individually or as a custodian or trustee of any entity, including Terra Santa Holdings, Orby Investments, and Buck Hill Trust.
So this is a slightly different discovery dispute. There's could we please have information about these trusts? Two of which your client's a beneficiary, and one of which Mr. Safier is a beneficiary. And so there seem to be some pretty clear financial connections to how a divorce would play out. Separate from that is, could we please have, and you pick Bank of America because we go back to all those inflows into the accounts, and the at least 5 million from at least 9 Bank of America accounts.
Yes, Your Honor. Yes, Your Honor,
Okay.
because they're transfers into the account. So we know that they're coming from other Bank of America
Yep.
accounts,
Okay.
which is what led us to say, okay, Bank of America, please provide, all the documents.
Oh, so your subpoena to Bank of America, was it tell us about these bank accounts, or was it give us anything that's associated, I'm going to use that generally, with Mr. Safier? Because it's his account, or where he is a custodian or has rights or authority in connection with a Bank of America account?
Yeah, it was the latter.
Okay.
It was the latter. Because again, we have all these accounts that are going into the joint checking account. And that's when we sent that to Bank of America actually contacted my office asking for an extension for 2 weeks because there were 32 accounts associated with Mr. Safier. Yeah, I don't know if those are all active accounts. I don't know if those belong to the trust, which, if we get these Bank of America records and we see that these are bank accounts that are trust bank accounts that are titled in Mr. Safier's name, then that would be problematic. And that kind of goes to the Gibson versus Gibson case where one of the accounts was not actually transferred into the trust because the husband had it still titled in his name. And I told you about the $5 million in deposits into the joint account from these mostly from the Bank of America accounts and Morgan Stanley. There's another $1 million in payments to his personal American Express card. Mr. Safier purchased a Ferrari in 2023 for cash, $450,000 for cash. That did not go through the joint account. So, and everything, the Bank of America accounts, the joint checking account, that's where it started to unravel for Mr. Safier, because I could start to see all these transfers into his account. When we get those Bank of America records, those are going to probably lead to other entities that we don't know about yet.
Probably so.
So, we need the Bank of America records. The court is correct that we will be filing a request to Morgan Stanley. We'll be sending them a subpoena. So we may be having another discovery dispute conference. But we are asking that the court compel all three trusts. And Your Honor, we are also asking for an order compelling Bank of America because once Mr. McGovern sent the letter, they ceased work on the production.
On the 32 accounts.
Yes, Your Honor.
Okay.
Your Honor, and I am,
When you asked Bank of America for that information, was it forever and ever, or was it as long as they keep records, or from 2020 forward, or?
Your Honor, I believe, and I've got it. I believe we asked going back to 2020, January 2020.
Okay, and all that's within the marital window. They were married long, long before that.
Yes, Your Honor. Your Honor, we asked, January 1st, 2020.
Okay.
Your Honor, and I am asking for attorney's fees pursuant to 9/11/37. Your Honor, and when I conclude, I can go over what my attorney's fees have been incurred.
Okay. We'll save that for the end. Who's up first on the other side?
Your Honor, I'm going to try to clean up some facts. You asked, by my count, 3 times, did you get documents? And her answer was no. On April 13th, 2026, Mr. Safay, through me, as part of the divorce case, produced the following documents. Buck Hill Trust, Morgan Stanley summary, including real estate sale and purchases, 201 Southampton sale, the 4360 Irma Court purchase, 201 Southampton documents, a warranty deed, clerk's receipt, warranty deed with corrected PT 61, a quitclaim deed, a certificate.
So before you read 2,000 documents into the record, are you saying we did produce some things, but we acknowledge not everything has been produced? Or is the through line, we actually produced everything? I'm going to impress you with how long the list is.
More towards the last one. We produced a lot. I think I said this to Ms. Shoemaker in some informal conversations. I don't mind saying it to you. My attitude was, she's certainly entitled, Ms. Safay, to look through the window, maybe even open the door slightly. We just don't want her going through the whole house and every drawer in there.
Why?
Because we don't think, and I'll let the full argument for the trust.
Sure.
To go all the way through everything a trust has. Because let me correct one mistake. You did see me nodding my head as a no. Ms. Shoemaker said, hey, if it's his separate property, that is a factor in equitable division. That is a true statement. What is inaccurate is that these trusts are not separate property. They are non-property. They are third-party property. Therefore, it isn't a factor in equitable division. That's why I was shaking my head.
Non-property Not meaning they don't exist, but
No interest in them. It's similar to Ms. Shoemaker says, oh, she was told there are 32 accounts. Well, 32 accounts of what? If my client has 32 Bank of America accounts in his individual name, absolutely entitled to them. Because what we produced on May 12th May 28th.
they're non-property because they're irrevocable. So let's just stick with Buck Hill. Your client is the grantor, so he put something into trust, and he did that for the benefit of Ms. Shoemaker's client and some other people, but she is one of the beneficiaries. But because I'm not a trust person, this is why I'm
Me
asking.
either.
Okay, so maybe you need to just not say anything, but this concept of non-property, I'm trying to understand it. It's non-property in the sense that Mr. Safai can't do anything with what's in the trust. It's not his anymore because he put it in the trust. And so we wouldn't put it on the scales of equitable division because certainly he's not going to be able to turn to Buck Hill, not so with Terra Santa, but Buck Hill and say, well, but I benefit from this and I can use it to get $450 to get a new Ferrari. He can't.
That's right.
It may have been his stuff that went in there, but it's an irrevocable trust and it's for the benefit of other people. And so it's as if his part of any estate shrank. He said, this is no longer for me. And it may benefit him phenomenally tax-wise, but it ought not then to burden him with, well, your universe of available financial assets is greater.
You're correct. And let me give you a simplified example that is not at issue in this case. Somebody creates a trust for a charitable foundation and they put $10 million, $20 million, $50 million in there. And now they go through a divorce. Well, that $50 million is not at issue. It is completely off to the side as if it's a McBurney account, as it's a XYZ company account.
Provided that your very generous donor somehow didn't engineer a way to have things transferred out of that charitable trust in somewhere else and their fingerprints on it that say, well, wait a minute, clearly it's not mine anymore, but that wasn't entirely accurate.
That's exactly right.
Okay. So wouldn't then Ms. Shoemaker be entitled to look through the window pretty darn closely to make sure that things hadn't been coming out of Buck Hill to pay off something with OPEX investments or whatever? I lost track of some of the tendrils, but it did seem like it wasn't an entirely, I poured in the corpus of the trust and that was it. That door locked and I didn't have the key to that door and I've been running signature tours ever since.
Essentially, that's right. Once it is put off to the side and he doesn't have an ownership interest, it is off to the side. It's a non-party.
Unless he makes it a party by saying, however he did it, because the trustee is his wife and she isn't objecting because maybe she's not even asked, and he's causing money to come out of Buck Hill to go somewhere else that's not then and there for the benefit of his spouse and his kids.
Well, but the Buck Hill Trust, as Ms. Shoemaker pointed out, was her own client. The trustee of the trust was her own client until February of this year.
Right.
So she is responsible for those transactions, not my client.
She is if she knows about him, but if she doesn't know about him and
Getting pretty far down the road when she says she doesn't know about things.
Okay.
There are other things, and I do want to bring it back to, for instance, the Bank of America statements, the 32. Well, I thought Ms. Shoemaker said it was 10, then she said it was 9. But what she's doing is identifying inflows, the source of inflows into Mr. Safai's records. We produced all of his bank statements back to 2000. So sure, you could see inflows and somebody may have a Bank of America account that pays him. You could have a friend who paid him. However, you don't then get all of that friend or all of that other entity's bank accounts just because they paid Mr. Safai.
right.
we certainly see the inflows. And I, again, 100% allowed to see what his inflows were. Now you're going to have to deal with the trusts as to whether the source and, or, you know, does Judge McBurney believe that those trusts have to show all of their bank accounts to justify that? So I wanted to be clear that we have produced documents. We have given enough information for her to analyze the trust. We gave that, I'll call it the dearth exhibit, the organizational chart on April 13th so that she could, Ms. Shoemaker could start to understand the workings of these trusts. We produced income documents, and not just for Buck Hill, we also produced for Terra Santa and and Orby Investments. For Orby Investments, it was the trust agreement, certificates of authority, certification of trust, promissory note to OPEX Investments from my client, the trustee removal and appointment, and for Terra Santa, the trust agreement was produced as well. So I just wanted to jump up and make it seem like, look, we have a disagreement about how much she gets to look.
Okay.
It wasn't a blank, you're not getting anything. Good luck with Judge McBurney.
Okay.
Thank you.
You're welcome.
Your Honor, out of respect for the court and the time of the litigants, do you have a hard stop at 3:30?
I don't.
Okay, because I knew it was going to be a 90-minute.
Yeah, because you get more than 12 minutes.
Okay, thank you. And I do
Talk
want to,
fast. No, don't. I'm kidding. Don't talk fast.
and I do want to defer to Ms. Newton, who is going to be handling most of the legal argument, as well as she can also highlight what has been produced and not produced, and she can discuss the legal authority. What I'd like to do is give you a background on these three trusts. First of all, I'm going to talk about a fourth trust that got mentioned earlier, and that's Miramar Trust. That is Mr. Mola's trust. Mr. Safier has nothing to do with that. So for the benefit of the record, I wanted to tell you that.
So before you say things that later on you have to unsay, when you say Mr. Safier has nothing to do with Miramar, what do you mean by nothing to do?
He's not a beneficiary.
He never received money from it? How did it come up? I'm not
I
remembering.
believe it came up in connection with a motion to disqualify Mr. McGovern, that it might be part of the litigation in Gwinnett County.
Okay.
Okay,
Got it.
they're nodding at me.
So it may well be that this Dr. Morris had some interaction with Miramar as well, or the infamous community healthcare is also maybe part of the corpus or was of Miramar.
Correct. And just to run that down, I'm glad you brought that up. Community healthcare was dissolved with the Secretary of State on September 19th, 2025. So I want to make that clear for the record.
Okay.
Okay. I liked how you referred to Buck Hill Trust as it might be too far removed. I'm going to take these in chronological order. As noted correctly by Ms. Shoemaker, it was created by Mr. Safier in February of 2012. Mark Dirth has been his long-term trust and estate planning lawyer, and he prepared this and has been with him for years. Ms. Safier was definitely aware of that trust because she signed as the trustee, and she was the sole trustee.
I didn't hear otherwise. It was the Orby Investment Trust that I heard Ms. Shoemaker say my client had never heard of Orby Investment.
Okay, and I will address that.
Okay.
But let me just say there's been a lot of reference to the fact Ms. Safier is saying, well, I didn't know about certain things that happened in Buck Hill Trust. Yes, she did. She
Okay.
had personal knowledge of the administration. But I also want to make a point.
So if she was familiar with it, why not let her see everything?
We think we have given her everything with respect to that. I'm going to let Ms. Newton address that.
Okay.
But I hear you. There has been a suggestion recently, not here, but in separate correspondence, that Ms. Safier may think she's still a beneficiary of Buck Hill, but she is not, because under that trust, although she's referenced as being a spouse and a trustee by name, Christine Safier, it is clear that under the beneficial designations that it's grantor's spouse, which is defined to be a person married and living together as husband and wife. And as reflected by Ms. Safier's divorce petition, they've been separated since January 2026, so they're not living together, so she's not a beneficiary. But the beneficiaries are, now keep in mind, Mr. Safier is not, But their two grown children, Tatiana and Brianna, and their descendants and any charitable organizations to be selected by the trustee. I'm going to tell you this, I'm not going to go through in the interest of time who got added as trustees or not. I do want to point out that, yes, Ms. Safier was removed as a co-trustee on February 25th, 2026. It was the day of divorce filing, but he did not know about it. Okay, so it was not anything nefarious.
Just a coincidence?
No, I think that probably there was an indication that they were going to get divorced because of that, but,
It sounds like Mr. McGovern and Ms. Shoemaker had been talking, so
right.
it was on the radar.
But let me just say this, that's not a violation of any standing order. He had the right to do it. And then also there was a reference to in April of 2026, because meanwhile, their two children had come in as trustees because in 2024, because Mr. Safier was in terrible health and he was worried about it and wanted the three of them, his wife and the kids, to possibly be on top of things if he passed away. But in April 2026, with their consent, the two daughters said, we don't want any part of this. So that's what they were removed, but with their consent, they did not want to be needlessly involved. And so Mark Dirth was appointed to be co-trustee along with Mr. Molo. Now, you do have the chart. The trust assets are, as indicated, the house on Irma Court. He lives there with one or more daughters. This has been agreed to. The property in Waleska, Georgia, which is affectionately referred to as the Lake House.
Is that the Hillside Drive?
Yes.
I didn't
And
know
that's-
Waleska was in Cherokee County.
That's in
Okay.
Cherokee County. And Ms. Safier resides there. Again, they agreed to this in a temporary consent order. 100% interest in Buck Hill LLC.
Yep.
Now, it is an investment holding company, and it holds cash, marketable securities, and similar assets. Now, I understand, Ms. Newton I've told her she's free to correct me if I say anything wrong. It's going to be on the record, not to circulate it to our colleagues at the law firm. But it shows Morgan Stanley investment accounts that's approximately $2.3 million in cash there. And they were produced. And there's also, and Mr. Gleckland just, with Mr. Safier, in preparing for this hearing, updated the financial affidavit. It showed that Buck Hill Trust has a loan from Mr. Safier of
A loan to or loan from?
a loan to the trust from him. So it's an asset. And that's on the revised, I said that right. From the trust to,
Okay, it didn't make, okay, that makes more sense.
okay, my bad.
No, it's
That's
nothing
it.
bad. I
That's
just,
it.
I needed to know which way it flowed. So I'm clear on this. The grantor of the trust that Mr. Gleckland says is non-property in this case, loaned himself money from the non-property.
But that was to purchase.
Whatever it was for,
Yes.
this non-property was a source of a loan to Mr. Safier.
But yes, but Your
You
Honor,
keep adding these buts. The answer is yes, it
Yes.
was. And for how much?
is that approximately, am I right about this, Emily?
I think we heard about this. This was the loan that ultimately helped support the purchase of the Irma.
Now, yes, and the trust agreement has very broad powers, Judge McBurney, that you can almost lend or take from any.
I'm not saying there was anything untoward about it at all. I trust it was consistent with the terms of the trust. It just makes the label non-property a complicated label.
Right.
But you're simply explaining what's going on.
And importantly, Ms. Safier was involved in all those transactions. So,
Also, okay.
yeah. And no distributions have been made to any of the beneficiaries. So I would like to turn to Orby. And that, as you know, was a irrevocable trust created by Mr. Safier in December 2019. We absolutely dispute. She knew about it. She knew about it. And that's just incorrect.
But does her knowledge or lack thereof really have any bearing on whether aspects of it are discoverable?
Yeah, well, okay, I would say yes, because it definitely cuts down on the ability to make a fraudulent conveyance claim if you knew about it.
Well-
Usually it's like, I didn't know about it and he transferred this property. That kind of thing.
But knowing that the trust existed, I'm going to assume for
Yeah.
purposes of our back and forth, we're going to have that Ms. Safier did know that Orby existed. That doesn't mean she knows what's going on underneath the hood. It sounds like she's barely allowed to look in through the window, and we only cracked the door open a little bit. So maybe she did know about it. Maybe she's forgotten. Maybe she's always known and she misstated something when she said, I don't know about it. That doesn't mean she knows what's going on in it or if money is sloshing between non-property Buck Hill and Orby Investments.
And I can say, I'm not, we do want to be cooperative. We understand. There may be, she may not have all the Morgan Stanley statements, and we're willing to discuss producing those to her for OPEX.
Okay.
But in any event, that is one where also she's not a beneficiary any longer for the same reason. But the other
Oh,
beneficiary,
because she doesn't meet the trust definition of spouse.
correct.
Got
And
it.
that's for Orby Investments Trust for the benefit of the court reporter, Article 12.7. Now, this is interesting. At the time of the divorce, the two trustees were James Mola and Danielle Safier, who is Mr. Safier's daughter by previous marriage. And the beneficiaries are grantor's spouse and grantor's descendants. So it would be all three daughters and their descendants. And I understand that Danielle has descendants. She has two babies. And so this is one of the reasons this planning is so helpful for that next generation. But sitting here today, Mark Dirth and James Mola are the two trustees. And Danielle got out of it the same reason. With her permission, she wanted to be removed and not be involved with that. All right, so let's talk quickly about OPEX investments. The trust does have an 100% ownership interest. We will be willing to provide more information about what is in there. But by the way, it got a big liquidity event happened, maybe within several years, where certain assets were repatriated from a European company. But no distributions have been made to beneficiaries in that trust either. And again, mindful of time, so I can get to Ms. Newton. Now, Terra Santa Holdings, this is that was one that Mr. Mola created. Okay, and you probably know this, Your Honor, is that when the grantor is the one not creating the trust, he just gave minimal $10 to fund it. But
Okay,
then it
because that
allowed-
answers one of my questions is what's Mr. Mola doing putting, I was gonna make a number up, $3 million. I love you, Tony. I'm gonna give you $3 million and put it in a trust.
He
That-
didn't.
He created it by putting the obligatory statutory $10.
Nominal.
So
right.
he's the grantor, but that opens the vessel into which then Mr. Safay could pour more or put corporate
Correct.
assets.
And so then Mr. Safay and his descendants, and those are, then those are the beneficiaries.
Mhm.
His descendants can enjoy the benefits of the trust. They can grow in assets. There's going to be no estate tax due. And by the way, Judge McBurney, I think Ms. Newton and I have been involved in a fair amount of these cases in divorce, and we're seeing that planning more and more. It's very, very smart because it helps protect taxes, but also precludes attack from creditors. And so it's a very common estate planning mechanism. So in any event, let me think. So what is in that trust? Again, so there's a 50% interest in Panacea Formulations.
Yeah.
It is an empty vehicle. And we can also provide information. on
Empty
that.
vehicle.
Meaning it was originally created to, believe it or not, source and formulate pain creams, but it never went anywhere and it's dormant.
Okay,
Mr. Mola's trust owns the other 50%.
okay.
And then, of course, Signature Tours has been referenced earlier, and that's, Signature Tours coordinates travel and tours for customers around the world. And Terra Santa holds a 1/3 interest, and Mr. Mola and another party trust own the other third. So in any event, this particular trust, though, has nominal cash. There are no distributions from the trust. And I recall that Ms. Shoemaker made a reference to something. She said, well, he had certain withdrawal rights. Well, he didn't do that, though. He only had withdrawal rights to take property the calendar year the property was given, and he never did that.
When you say things like Terra Santa Holdings has minimal cash, you know that because you're privy to some records. You're not making that up, I know. would Ms. Shoemaker be in a position to say the same thing because she can look at the same record? So she's not being surprised by you saying, Terra Santa Holdings Trust has minimal cash. She's got the same type of records.
Understood.
No, I'm not asking if you understand. I'm asking, does she have the kind of records that would enable her to concur with you that Terra Santa Holdings Trust has minimal cash?
Well, the only reason why I'm going to object to what you're saying, Your Honor, in this particular case, she's not a beneficiary. And so she has really no rights to that. if that
Okay,
makes
but so
sense.
the answer is no, they wouldn't yet have that. It would be a reason why you or someone has been resisting production of records that would enable Ms. Shoemaker on her own, not just relying on your word, to confirm that there's not a lot of cash sloshing around in Terra Santa
I hear
Holdings
you.
Trust.
And Your Honor, we are more than willing to be reasonable about providing some helpful information to her. And I'll let Ms. Newton talk about that a little bit more than I do.
Okay.
I'm glad that Mr. Glecklin talked about the concept of third-party property, because that's a big issue in ours. I believe the Gibson case that was referenced, which Ms. Newton and I were involved in, and Ms. Gilbert's firm was involved in, everybody was involved in it. That is the fact that you have marital property, separate property, and third-party property, which is off limits. So we would contend that that's, I think, Your Honor,
But if Terra Santa Holdings, different from the other two,
yeah,
if one of the beneficiaries is Mr. Safay,
correct.
then that seems like an asset pool that is relevant to decisions I might be called upon to make. If it was, and well, you didn't tell me what's its creation date?
December 31st, 2019, same
All right.
time as Orby.
Got it. So during the marriage, this trust was created by Mr. Mola, but if Mr. Safay is putting things in it, whether it is 1/3 share of Signature Tours or the apparently valueless right now Panacea Formulations or anything else like this minimal amount of cash, how is that non-property?
Okay.
Because
let me hand it to the
it
court.
could, yes.
Not only a beneficiary, he's a co-trustee with
Yeah.
Mr. Mola, but he is not allowed to make any decisions at all concerning distributions to himself. He can't be a part of it. But so my point is, Your Honor, I would almost view it that this is looking into the future, trying to predict what might happen. But yes, he's a beneficiary, but he's not one that's, to be honest with you, these cases, you kind of look at the history of distributions. You don't have that here. So I would almost.
I guess we don't. I don't know whether there's distributions or not. And it sounds like Ms. Shoemaker would say, I too don't know if there've been distributions from Terra Santa Holdings.
Well, how about this? Let me, not to kick it, try to do that, Ms. Newton has the legal arguments ready as well.
Okay. But this was a very helpful overview of sort of structure and what's been going on with
Right, I
this.
appreciate your patience with us.
Okay.
All right.
Good afternoon, and thank you for the additional time to present these arguments. I also am from King and Spalding, and I represent Mr. Dirth and Mr. Mola as co-trustees of the various trusts we've already been talking about today. We are seeking an order quashing the subpoenas directed to the trustees of the three trusts and Bank of America, as well as a motion for protective order.
And your status, the Bank of America one, that wouldn't have anything to do with Mr. Dirth or Mr. Mola, because the subpoena was produce any account that Mr. Safay appears to be connected to.
So it's a bit nuanced. The Bank of America subpoena was directed broadly to Mr. Safier in terms of any individual accounts he had, but also if he was care of on various accounts related to the trust or Signature Tours.
Yep.
Terra Santa Trust owns 1/3 of an interest in Signature Tours. And one of the bank accounts that Ms. Shoemaker appears to be interested in is a Signature Tours bank account. That is a a third party. It's a Georgia corporation, of which Mr. Safier has no individual interest in. He's a CFO. Mr. Mola is the CEO of this entity. And so we have joined in the motion to quash that subpoena on behalf of Mr. Dirth, because he is a co-trustee of the Terra Santa Trust that owns a third interest in Signature Tours.
So it is a little nuanced in that really you don't have a basis to be opposing the production of Bank of America accounts not connected to Signature Tours. I'm making this up, but let's say 5 of the accounts are just in Mr. Safier's name and nothing to do with, on the face, nothing to do with Signature Tours. You aren't really in a position to say those shouldn't be handed.
No, we are not opposing production of that. My understanding, as Mr. Glecklin has presented, that information has already been provided to Ms. Shoemaker. So those are his individual accounts. So no, we are not objecting to that. Our position is that we believe she has that information already.
Okay. All right.
So our position is that the subpoenas seek depositions and broad document requests concerning the assets, liabilities, financial records, and other information pertaining to property held by these trusts, which I'll get into more, but these are third-party property not subject to equitable division or claims of alimony. These requests, from our view, are unreasonable, burdensome, and not relevant to the issues in this case. I will start by noting that there were several inaccurate statements indicating that we have not produced anything related to these trusts. That is inaccurate.
Okay, and both Ms. McDonald and Mr. Glecklin have covered that. So.
Yes, and if I may, I will not, I don't want to waste time here, but I do have just a summary of the productions that have been made.
Okay.
If it will be useful, if I can approach, and I have
As long as you've
copies.
shared that with Ms. Shoemaker, that's
Yes,
great.
of course.
Thank you.
And I will not go through at length all of this again, but it suffice to say that there have been many documents produced related to the trust, including the trust agreements themselves, certificates of authority, documents concerning the appointment of various trustees. We also submitted on behalf of Mr. Mola affidavits that provide additional information about property held in the trust. That was produced as well. And it was similar to the information that Ms. McDonald just presented to you. So at base, it's our position that Mrs. Safier has the information that's relevant for purposes of determining equitable division and alimony in this case. And from our perspective, what is not okay is she is not entitled to discovery beyond this foundational information because it's held by third parties that are not part of this divorce. The third parties are not, the trustees are not parties to this divorce action. It's between, of course, Mr. and Mrs. Safier. And importantly,
Mr. Safier is a trustee of one of the 3 trusts.
he is, although he is not a party to the divorce case in that capacity. So he is not a party as a trustee. He is a party as an individual.
He is, but the trust is for his benefit as an individual, not as a trustee. So that seems like your hardest argument, that what's going on with Terra Santa has nothing to do with a decision that would need to be made about alimony, what's in the marital estate, equitable division.
Yeah.
So I don't know if you want to save that one till last or start with that one.
I'll address that in just a moment. I
Okay.
just want to be clear, though, that what Ms. Shoemaker is seeking right now, these motions are about, she says is relevant to alimony, and I'll address why this information is not relevant to alimony determinations. But she also seems to be saying that she's interested in this information as well because she might have something like a fraudulent conveyance claim or something where she might want to add the trustees to this divorce action and expand greatly the scope of this case. The issue here is she's seeking discovery to see if she has claims, and that's not appropriate under the Georgia rules of civil procedure. She needs to assert claims if she has them, and then she can seek certain information related to those claims. We don't have fraudulent conveyance claims or anything else related to the trust.
But she's asserted a claim for alimony.
She has, which I will address.
And in sorting out alimony, you look at both sides' assets and income and ability to pay, et cetera. And if the financial affidavit paints a picture of Mr. Safai as not quite being penniless, but sort of on paper, just not having many assets, and yet there's a Ferrari purchased with cash. There are these millions coming into the bank account, but they're not direct deposits. They're just these, I'm going to call them mystery transfers, not because they're unknown to you and maybe not even unknown to Miss Safai, but that you don't point to, that's my job at General Motors. It's just, there's money. This money comes in and we can have a lake house and we can have a Ferrari and we can have this nice house on Irma. Why is the mystery surrounding the inflows not a sufficient basis to say, I need more discovery to demonstrate that there is an apparent capacity to pay a meaningful amount of alimony that doesn't jibe with the financial affidavit. That's out there now, and this discovery is targeted to explain that disparity, that lack of connectedness between the financial affidavit and the reality of the bank accounts.
Yeah.
So to me, one, it's not a fishing expedition, but two, I'll just push back gently on your characterization of what discovery is for, because I'm sure in another setting, you've said, of course we should get that because discovery is broad. And maybe we don't find something that we could use at trial, but that's never the litmus test. Could you use this at trial? As long as it's designed to develop a theory of your case. And I feel like Ms. Shoemaker articulated pretty clearly a theory that there's this other current of money flowing through Mr. Safai's life that is not reflected in the affidavit, but it's out there. And I would think the opposing party in a divorce is entitled to understand the depth of that current and its flow and what are the inflows to it. And the reality is, it sounds like some of that has to do with the trusts.
Yeah, and so let me address that. I do want to address McGinn first, though, because that is the case that she says provides her the ability to seek this information for purposes of alimony. So in McGinn, the husband was a beneficiary of a trust. The sole asset of that trust was stock in a company owned by members of his family. He was also co-trustee of that trust. And most importantly, which is a key distinction here, he held a general power of appointment, which meant that he had control over the assets in the trust and could appoint assets to himself.
And Terra Santa isn't structured that way.
That's correct.
Okay.
So Terra Santa, he is a co-trustee along with Mr. Dirth. He is a beneficiary along with his daughters and descendants. However, there is a specific provision in the trust agreement, that's section 10.4, that prohibits Mr. Safai as trustee to make any distributions to himself. He cannot do that. It would have to be authorized by the co-trustee, Mr. Dirth. In order to
Who
do
is
that.
not your client's arch enemy. Oh, we agree? It's not like Lex Luthor and Superman are the two trustees.
Mr. Dirth
It's
is
like my
a,
lifetime trust and estate lawyer who knows how much your client has paid him over time. And that's the guy who's the check on, I would like to distribute some of this trust that I've funded to my benefit.
yeah, Mr. Dirth is a well-respected.
I'm not
Yeah,
casting
you're
no aspersions on him. I'm sure he's an excellent lawyer, counselor, fiduciary, et cetera, but you acknowledge that that's the co-trustee.
That is the co-trustee.
Yeah.
It's also important to point out that distributions from this trust are discretionary. So these aren't mandatory distributions. There isn't a regular rhythm of distributions coming out of this trust. In fact, there have never been any distributions from this trust.
Okay. You say that, but how is it that Ms. Shoemaker is supposed to know that other than that you say that?
Well, the Bank of America statements have been produced. So if distributions were coming out.
Whose
into
Bank of America statements?
The
The
Mr.
family
Sapier's,
ones, right? And
yes.
so if there's this, hey, $1 million just came in from this account, how is Ms. Shoemaker supposed to know that's not a Terra Santa account until she follows up to say, what is the Bank of America account that pushed $1 million in? Or what is the Morgan Stanley account that pushed money in? And I'm hoping for what you're saying. It's not Terra Santa that did that. But that's not knowable until some of these subpoenas are complied with, unless we just say, because your client says it's so, it's so. And of course, that's not how discovery works.
Yeah, and just to be clear, so we have complied with the subpoenas in that we have produced information, and Mr. Safier has produced additional information. They have the Morgan Stanley account statements that are related to Buck Hill LLC. Those were produced very early on. They have other statements from Morgan Stanley that are related to Buck Hill Trust. They have the note that is owed from Buck Hill Trust to Mr. Safier. That stemmed from an initial loan back in 2012 that Mr. Safier made to that trust. They have that as well. That would go back into the marital estate. So that would be marital property, right? Money owed. So they have that information. In terms of OPEX and its relation to this note that Ms. Shoemaker was discussing, they have a summary document that goes through how this transaction occurred. Not to get into too many details, but Mr. Safier borrowed money from OPEX LLC, which is an entity held in Orby Trust. He then individually loaned money to Buck Hill Trust, so Buck Hill Trust could purchase that money or purchase that marital residence. Another property was then sold in Buck Hill Trust, and the assets from that sale were then used to first satisfy the note Buck Hill owed to Mr. Safier in his individual capacity, and then to satisfy the note that he still owed back to OPEX. So the money can be traced. They have a summary document, and we would be willing to, if they do not have the promissory notes related to that, certainly produce that to them. The first time Ms. Shoemaker raised not having that information was actually in the brief that she submitted to this court.
Okay.
So if I can just go back to McGinn just for one moment, the reason we believe that this information is not relevant to a determination of alimony is that for Buck Hill and Orby, he's not a beneficiary. He's also not a trustee. So that's very much unlike McGinn. And in Terra Santa, of course, while he is a co-trustee and a beneficiary, he cannot compel distributions to himself. He doesn't have a general power of appointment. He really has no control over any distributions being made to him that could be then considered as part of a separate estate for purposes of alimony determinations. So that is our position there. In terms of Bank of America, as I noted, we represent Mr. Dirth, who is a co-trustee of Terra Santa. The bank accounts that they seek there, one is for Signature Tours. That's a Georgia corporation. That is not an individual account of Mr. Safier's to compel information about a third-party entity that's a Georgia corporation. Information about that company we don't believe is appropriate. And similarly, we've talked about community healthcare a fair amount, but that we understand is a dissolved corporation. It has no assets. There is nothing in that bank account. So it is our position that information has been produced. To the extent there are questions about the note that I just discussed, that is something certainly we're willing to produce to Ms. Safier. We just learned of that request. In terms of, I think there were some statements made about income coming from OPEX LLC to Mr. Safier. OPEX LLC is it has an operating agreement. Mr. Safier is the manager of that entity. And so he has taken certain consulting fees as manager. The sole member is Orby Trust. Orby Trust must approve any of those payments, which it has.
Meaning Mr. Mola and now most recently, Mr. Dirth need
Correct.
to approve.
Correct. Apologies, I'm just looking to see if there were any other statements that I need to address. I'll also just point out, Ms. McDonald addressed this, but during the time of these loan transactions that I just addressed, Mrs. Safier was a trustee, especially in 2024. I believe her daughters were as well. And so she had to approve the note that happened and sign off on it, as did her daughters as co-trustees. So the statement that she had no idea about what was going on, these were all transactions that she approved of and she supported. It was their marital home. They were buying a home. She wanted to redecorate it and make improvements. And so that was all known to her. So those are the main statements, unless Your Honor has any additional questions.
I have an overarching one, which is why not just provide the information? Is it more you're taking a policy stand and want to make sure there's not a bad precedent set for future successful business people involved in a divorce? Because it certainly makes one wonder, if there's nothing to hide, then just hand this stuff over. Different from Signature Tours bank account. And that's one that I'm going to engage Ms. Shoemaker with. I don't know why you'd be getting into. Maybe McDonald's Corporation paid Mr. Safier a consulting fee and there's this transfer. It's odd that that's how they pay them, but McDonald's wouldn't pay that way. But a private LLC, they might pay just by transferring some money. You don't suddenly get McDonald's bank account. So that I get. But for some of these, because of, I'm going to use the word murky, and I don't mean it in a pejorative sense, but just the way money flowed in Mr. Safier's life, because he's got different business interests, but they're private. And so you're not getting a W-2 or a 1099, makes it a little hard to suss out where's the money coming from and is it recurring and whatnot. Those seem like legitimate inquiries. And then when a judge hears, and I'm hearing now, it's not that nothing was provided, but it still was, well, we'll open the door a little bit and you can look in, just let her in, unless it's not the recipe for Coca-Cola. And if we need a protective order, it's a protective order so that it's for attorney's eyes only. It is an understandable fact-finding mission. How much money is out there so that there is a fair outcome in the end and we're not undercounting for anyone. And it lends this little bit of aura of, oops, I don't want them to find the $10 million in OPEX investment. And so don't go there.
Yeah, and to address that, Your Honor, the point is not, we are worried that they are going to discover something and it's terrible and this was hidden. It is not that at all. It's because we are respecting the third party property. It is property that under Georgia law, under Gibson, under Armour versus Holcomb, it is not relevant to the determination of an equitable division award unless they have asserted fraudulent conveyance claims or certain other claims that would somehow unwind the transfers or unwind the actual trust itself, drawing those assets into the marital estate. And so, our argument is that it's not relevant to the current issues in this case. They haven't asserted those claims. We don't think they're valid. We don't think there is any fraud there. But it's really respecting the third party property that from our perspective has nothing to do with equitable division or alimony, which is what she is focused on today.
Sure. Okay. Well, you can understand how it will be pretty frustrating if we're back together in a few months because there's been a fraudulent transfer claim asserted and there seems to be some initial merit behind enough that we're going to have to pry things open because here you are saying you don't need to worry about that.
Certainly, we understand that, Your Honor. There are also, to add trustees to a case, a divorce case, there are certain, they need to assert that there has been fraud, which we're not there. They have not done that.
Okay. All right. Thank you.
Thank you.
So Ms. Shoemaker, you've got a little bit of time if there's something you want to say in rebuttal. I know you want to talk about your attorney's fees. I'd like you to start by reconciling for me, Judge, all we have is the trust agreements and nothing more, with some fairly specific,
Yes, Your Honor.
that's more than the trust agreement. Some of them is not. It's just the trust agreement, but it sounds like you've seen I got some Morgan Stanley statements here and cash flow summary. And so I'm feeling like it was more than what you originally said.
Your Honor, let me clarify. And let me go through this list. So I
don't want you to go through the whole list. It's a long list, but it's more than just the trust agreement.
Your Honor, it's not a long list.
Okay.
It's not. It's made to appear.
At 4:00, it's a long list. How about that?
Your Honor, I have the trust agreement. I have the deeds where the original marital residence that was located on Southampton Circle, where it was transferred into the trust. I have then where the current marital residence, Irma Court, was transferred into the trust and then transferred out of the trust and then transferred from Ms. Safier to both parties. And then I have where it was transferred back into the trust. I have, so again, that's publicly available information. I can go on the clerk's website and get all that. They have provided me with the promissory note. So when Mr. Safier established Buck Hill Trust in 2012, he signed a promissory note to the trust for $823,000. I have that. Your Honor, then, the protector appointment, protector removal, those are where Mr. Safier removed my client.
She already knew about that probably.
He produced.
Before you got this produced, she probably knew.
No.
Or she learned that she'd been removed only because of this discovery production?
Yes, Your Honor.
Oh, okay.
Yeah, we learned about it when they produced it in his initial discovery production in April of 2026. The cash flow summary, Your Honor, that is a one-page summary which indicates that Mr. Safier signed a promissory note to OPEX Investments, which is part of Orbi. And that's amazing. I mean, if he just does consulting work, that's amazing that OPEX Investments gave him $2.8 million to buy a house. So I've got that cash flow summary. It's about 6 lines, Your Honor. So where are the statements that support all of that? Your Honor, and Buck Hill Trust, they gave me, and they say the May and December 2024 statement. They're not even statements. It's a custom report. And it's titled in Buck Hill Trust, right? So they said that Buck Hill Trust has Buck Hill LLC, and Buck Hill LLC is just an investment or holding company that has a $2.4 million Morgan Stanley account. And that's in the name of Buck Hill LLC, care of Anton Safier. Well, that's interesting because in 2024, if it's the same account, that account was titled in the name of Buck Hill Trust. So how did it go from Buck Hill Trust to Buck Hill LLC, care of Anton Safier, when my client was a trustee? And I heard today that at some point, they said that the daughters were added as co-trustees in 2024. I don't have any documents stating that they were added in 2024.
You received it was Buck Hill 00001. That's the Bates range.
Your Honor, which page are you looking at? Are you looking at the
Page
last?
5 of what you say is this really short list. And it's the second entry in the Buck Hill Trust KNS.
Okay, Your Honor, and I'll trust that they provided that.
I mean, it's one page, so.
Your Honor, again, my client didn't know about this, and the first time we get it is on June 22nd of this year. Your Honor, their claim is, particularly with the Buck Hill Trust and the Orby Investments Trust, that this is non-property. Your Honor, and I want to clarify one thing on the Miramar Investments Trust, which is not at issue right now before the court. But I do want to clarify because they did provide the trust agreement on that. Mr. Safier is the trustee. He's a co-trustee on that. So it's not appropriate to say that he has no association with that trust. That's not accurate. Your Honor, regarding Buck Hill Trust being non-property. Your Honor, this goes to Gibson versus Gibson. We are entitled to the discovery to show that these were legitimate transfers, and that they weren't fraudulent. Your Honor, the Morgan Stanley account. That's a prime example. First of all, my client was a trustee and didn't even know that this account existed. And then somehow this account, again, if it's the same account, went from being titled in the trust name, Buck Hill Trust, in 2024, because they've given us, it's not even a full statement. It's a custom report. And that's also, a custom report that shows just a snapshot in time of the money coming in from OPEX investments and then going out to pay off Mr. Safier's promissory note to OPEX investments, which is also very interesting because if you're just, a consultant, I don't know why they give you a $2.8 million loan.
What is your response to the observation that Signature Tours Bank of America account really ought not to end up on your desk because that's an ongoing business? And what are you doing looking in their bank account?
Your Honor, Signature Tours was established in 2017 by James Mola and Mr. Safier. Terra Santa Holdings was established December 31st of 2019, the exact same day that Miramar Investments Trust was established. And so, and Miramar Investments is a mirror image of Terra Santa Holdings. So Terra Santa Holdings, James Mola is the grantor, Tony Safier is the beneficiary and co-trustee. Miramar Investments, Tony Safier is the grantor, James Mola and his family are the beneficiaries, and Tony is Mr. Safier is I have to go look at exactly who the trustees are on that one. So it looks like Mr. Mola and Mr. Safier established Signature Tours and then said, okay, we've got this business that must be making money because they're very sensitive about Signature Tours. And so they're like, okay, let's put it into these mirror image trusts, and you're the grantor for one, I'm the grantor for you. 1/3 ownership. I don't know where the other third is. Maybe there's a third business partner out there on Signature Tours that we just don't know about yet. So now the question is, under Gibson versus Gibson, was that a legitimate transfer? Okay, and I would question that based on the amount of control that Mr. Safier has continued to exercise over these trusts, and not only the control, right? He's maintained. These are irrevocable trusts. The whole point of an irrevocable trust is it's a separate entity. You put the money in there, and you have no more control over it as the grantor. That's not the case here. We still see Mr. Safier. His hands are in all the pots. And if it's not him, then it's his business partner, James Mola, or the man he paid to set up these trusts. And oh, by the way, Mark Dorff was only added as a co-trustee to these trusts in April of this year. On Terra Santa Holdings, the prior co-trustee was Danielle. his oldest daughter. Your Honor, so, and it also goes to McGinn versus McGinn. So it's Gibson versus Gibson, were these legitimate transfers into these trusts? It also goes to McGinn versus McGinn because the value, McGinn versus McGinn, you had a family-owned LLC in the trust. And the Supreme Court said, look, trial court, you erred by not allowing the wife access to the discovery of the financial information in order to value the stock of that family-owned company held in the trust, because it went to the value of the corpus of the trust and how much potential benefit the husband would receive. It's the same thing here with Buck Hill and with Signature Tours, and how much is that worth, and what is the potential benefit and the potential, separate estate of the husband. So that's why Signature Tours is relevant. It's the financial records. It's the bank account statements. It's the $6 million. Where did the $6 million come from? They say they've given us everything.
They didn't say everything.
Well,
They said it was more than nothing. That's a big gap.
Yes, Your Honor. Yes, Your Honor. But I would tell you that in my position, I believe that it's closer to nothing.
Okay.
As if on the spectrum of 0 to everything, it's closer to 0.
All right.
We've got no information on OPEX Investments, LLC. We have no information on Signature Tours, Panacea Formulations, Buck Hill, LLC, Community Healthcare, Botana Medics, LLC, Global Investments Limited, LLC. And nobody's even talked about that. I don't even know where it is, from which he got $1.6 million from. Is that another consulting thing, or is that another business within these trusts? We don't know until we actually get the discovery from the trusts. I'm just looking at my notes, make sure I hit. I believe that's all the high points. But my client, under Gibson versus Gibson and McGinn versus McGinn, she should be entitled to all the discovery on all 3 of these trusts. They again argue that there's been no distributions from Terra Santa Holdings. Your Honor, I have no documentation to show that, to prove that. But Your Honor, even if there haven't been any, we're still entitled to know what the value is of that trust and those assets in the trust. Your Honor, and also in conclusion, I am asking for attorney's fees on my motion to compel. Your Honor, prior to today, my bill was $11,836. Your Honor, I do have a copy. That's just the discovery piece, which is what this has mostly been, is the discovery on the trust thus far. Your Honor, my additional fees today are $19.25. My co-counsel, Ms. Gilbert, of course, we brought on co-counsel because of her expertise in trust. Both her and Ms. McDonald and Ms. Newton were on the Gibson case and the McGinn case. After today, our total bill is $13,761. Your Honor, I am billing at a rate of $450 an hour on this case. I've got 17 years of practice. Been licensed that long, all in family law. Your Honor, I do have a copy of my attorney's fee statement if the court would like it, and I will stand subject to any questions from opposing counsel on my fees.
Have they had a chance to look over before just now your statement?
They have not.
Okay.
We've not seen it yet, Your Honor.
Okay.
Not that that's directed to me. It might be more directed to Mr. Glecklin.
So, Mr. Glecklin, I don't mean to put you on the spot because you just received that. The billing rate seems reasonable to me. So really would just be a question of whether, when you have a chance, and it doesn't need to be right now, if you feel like there are entries in there that don't make a ton of sense, maybe we could just over email have a back and forth and say, oh yeah, you know what, that looks like that's related to preparing your initial complaint or whatnot. But I want to give you a chance to fly spec it to see if there's either some type of bulk billing or whatever we call it, bulk entry, or something that just doesn't look like it's connected to the back and forth over discovery.
let me first address the hourly rates are reasonable under the circumstances and given counsel's experience, so I have no issue with that. And I would just like, sometime tomorrow, I could email the court, obviously with a copy to counsel to indicate if there was something to your point that was, perhaps inaccurately
Yep.
included.
Let's do that. So we'll just say by close of business tomorrow, email Ms. Niles. Either way, it looks fine or got a couple questions, and then we can sort through that. We don't need to drag everyone back into court to do that.
That is correct, Your Honor. That's totally fine. It'll be done by probably long before the end of the day.
Okay.
Tomorrow, but by the end of the day tomorrow. And I just do feel the need to at least object for the record. You heard the phrase $6 million multiple times. There's no evidence before the court that there's $6 million of inflows into his accounts.
There have been 5 million in the opening statement, but maybe just with inflation, it went up during the course of the hearing.
And if we ever are back in front of you, you'll see a lot of double counting. There are transfers from his savings account to his bank account of millions of dollars. So I don't think that is the issue for Your Honor, but I'd be remiss if I didn't point out that we
Okay.
object to that calculation.
Okay, fair enough. And it could be that in part it's difficult to calculate based on the way things have been produced or what hasn't been produced. So who knows? We will save that for a future day.
Understood. Thank you.
All right. Ms. Shoemaker, anything else on behalf of your client? Okay. Mr. McGovern, I don't think anything came up during the lengthier discovery session, but I don't want to prevent you from adding something if you heard something that you think bends back onto this question of your proper role in this litigation.
No, I did not, Your Honor.
Okay. All right. Anything more? Okay. Anything more from Team KNS?
I don't think so. Thank you, Your Honor.
You good?
Appreciate
All right.
it.
Mr. Gleckman?
No, Your Honor. Thank you for your time.
You are all welcome. Are you sharing takedown?
Yes, Your Honor.
Yes, Your Honor.
They will bill you. All right. Thanks, everyone.